Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's presidential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. I recently caught up with the folks at e-immigration who shared a big announcement, hot off the presses. Have you heard? E-immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. I am not one to rejoice at the firing of good people from federal government, but I will say that one of the benefits, if ever so small, is that now they can talk. I recently did just that with former Appellate Immigration Judge Andrea Saenz. And if I may be so bold, it was an excellent discussion filled with all the knowledge. You're mere minutes away from finding out for yourself. Since leaving EOIR, Judge Saenz has been at the entity Co-Counsel, a nonprofit legal services organization that partners with community-based organizations, law firms, and companies to respond to the emerging, complex, and ever-changing legal needs of immigrant communities. We'll hear a bit about that later in the episode and can find links to Co-Counsel in the show notes. Judge Saenz, of course, is an immigration lawyer, teacher, and writer with over 16 years of experience in nonprofits, government, and academia. She previously served as an appellate immigration judge with the BIA from 2021 to 2025, adjudicating thousands of appeals and motions and training new immigration judges and attorney advisors on asylum law and discretionary relief. Judge Saenz also helped build New York's universal representation programs as the attorney in charge of the New York Immigrant Family Unity Program at Brooklyn Defender Services from 2016 to 2021, where she supervised and litigated detained and non-detained removal defense cases, including groundbreaking federal district court and circuit court litigation, challenging detention and removal. She's been a clinical teaching fellow at a law school immigration clinic, worked as an immigration staff attorney at the U.S. Court of Appeals for the Second Circuit, served as an attorney advisor with the New York Immigration Court, and began her career as an Equal Justice Works Fellow at the Political Asylum and Immigration Representation HAIR Project. Oh, and she's a former teacher and Harvard Law grad. Just about the exact person that I'd think the country would want at the BIA. Maybe she'll return someday. But for now, she's talking to me. Let's talk, Judge Saenz. Former Appellate Immigration Judge Andrea Saenz, welcome to the Immigration Review Podcast. It is the evening of June 10th, 2025. How are you doing tonight?
I'm very good. Nice to see you, Kevin.
It's great to see you. We have had the pleasure of meeting one another. Well, the pleasure, I definitely had the pleasure. I don't want to speak for you. It was a pleasure for me to meet you. We'll let you decide whether it's a pleasure to meet me at some Federal Bar Association Immigration Law Section conferences. Yes. It's one of the reasons I love the FBA. It's for the private bar and the government can meet, mingle, drink a couple of drinks, eat some pretty decent appetizers. So I'm glad that we were able to connect now.
Yeah, thank you so much. I've listened to the podcast for a long time, so it is really fun to be on.
It's an honor that you or anyone at the Board of Immigration Appeals or in the UIR, or quite frankly, anyone listens to the podcast. You're no longer at the Board of Immigration Appeals, not to let the cat out of the bag, but, just get started. Ask a few questions about your time at the board. The most important one everybody wants to know, was there an Immigration Review podcast sticker present in the Board of Immigration Appeals? The hard questions starting off.
Yes, there's at least one. Actually, I know that there's a couple, but there was one displayed in my office because you gave it to me at FBA a couple years ago, and I put it on my plant on my windowsill.
I am shameless. That sounds like me. I don't remember it. I'm glad that it made it onto the potted plant. Why the plant?
I didn't have that many other places to put it. Some people put stickers on their laptops. I thought I shouldn't do that on government property. So I had a little plant on my windowsill with a lovely view of Alexandria, and I put my sticker there. And I do know you have other listeners inside DOJ.
Oh, it's very kind, and that's an honor. I'm going to just assume it was a prominent plant, big plant, right in your line of sight. So really, really honored to have you and to have such a fan.
Yes.
Thank you for being here with me today. You are the first former government employee that I've had on the podcast since the change of administrations. I've wanted to have former government employees on. Some former government employees have reached out to me. I'd be happy to have them on. Our schedules just haven't aligned. But the private bar has a lot of questions, and I'm sure that the current and former government employees have a lot of questions as well. Now, I want to be respectful of you. There are certain things you can't say, shouldn't say. And so I just want to hear what you have to say.
Yeah, no, I appreciate that. I don't think it's a secret that I did have to leave the board in the last few months, and that wouldn't have been my choice. It was a wonderful job. It was an honor to be on the board, and I would like to keep serving in some capacity. But here I am. I'm back doing, removal defense and supporting folks however I can. So if I can use that experience to give people some insight into their appellate work, their client representation, then I'm happy to do that.
And you get to be on the Immigration Review podcast. If you had taken the fork, which the fork I don't think was offered to you, had you taken the fork, you still wouldn't be able to be on. So, what's the phrase there? Lemons into lemonade. That's what it is.
I suppose so.
I'm paying you a lot of money to be on this episode, so you should. You can't deny it. No one will know. We have a lot to cover. I have been wanting to talk to you and been excited for this interview for quite some time. But as with any guest on the show, and especially someone who's made it all the way to pretty much the highest level you can in the immigration world, I'm interested in your personal story, your law school story, and what led you to immigration work and the kind of work that you do.
Yeah, thank you. I love hearing from immigration lawyers how they came to this field, because sometimes people have very personal connections to it or intellectual connections. And I think it all just makes for a really interesting group of folks. For me, I am the first lawyer in my family. I didn't really think about going to law school, certainly didn't think about being a judge. And I went not to law school right away, but I went to Teach for America, where I was teaching English as a second language in Houston right after college, trying to decide what I wanted to do. I am a former college debate kid, and a lot of debate folks go to law school. Mm-hmm. And I didn't want to just go to law school because I didn't have a better idea. So I went to teach. And then I realized that one thing you can do with a law degree is work with, communities that don't really have a lot of insight into how the legal system works. Teaching ESL, all of my students, it was their first year in the country. And I found myself wondering what was going to happen to them. Were they going to be able to go to college? Were they going to have their own families and find a sense of stability? And I decided that was one reason that it would be meaningful for me to go to law school, was to work with immigrant communities and see if I could provide information and service in that way.
Maybe it was my law school, but I get the feeling that it's universal. There is no group of people more passionate than the Teach for America people in law school. The people that have seen the American education system, usually in the poorer regions of the country, and who want to do good and do change through law school. They are fierce folks. Confirm it or not. Well, was that you? Were you a fierce folk?
Yes, I think so. Well, I mean, look, I've always been a passionate person, a stubborn person, a competitive person. That maybe that's why I did debate, why I love, games and trivia and that kind of stuff. And I found that law and immigration law is a great way for me to channel some of those aspects of my personality in a way that can be of service. And that's actually the first time I ever heard someone use the word dreamer was when I was in Texas working with young immigrant folks. And I just found that to be something that was actually a little bit out of my personal experience. I'm Mexican American. I'm from Los Angeles. My parents were born in the U.S., so I actually don't have an immigrant story. But I was really struck by this idea that these kids that I was working with were, born in a different country. And it seems almost by chance, right? Sometimes you meet someone and you feel like you have something in common with them, but they actually are coming from a very different place. And because they were born in a different country, were they going to have different options for their future than I was able to have growing up in LA? So that was one of the questions I had that drove me to immigration law.
Completely by chance. I tell my 9-month-old every day to recognize his privilege and his fortune, and he doesn't take it kindly. He's 9 months. He usually then defecates or does something, but he needs to understand how arbitrary life is. He's gonna have a lot of issues, as you can tell. Why detention work though? Detention work is so difficult. It happens so quick. You have limited access to your client. It's hard to be the lawyer sometimes that I know that you want to be, with the best arguments and all the evidence. I mean, why detention work?
Sure. Well, I got into detention work a little bit by accident because when I was in law school, I'm going to date myself here, but in 2007, there was a very large workplace raid in New Bedford, Massachusetts. And that was the first time that I saw who could be detained. It was actually completely new to me. I had no experience with immigration detention. I didn't actually know that that the government could detain parents of small children. There was a workplace raid at a factory that involved detaining some folks whose kids didn't get picked up that day. And that really made a big impression on me when I realized that the Boston immigration community mobilized overnight to go find these folks and get the chance to talk to them and represent them. And I was lucky enough to continue working on some of those cases later when I was at the PAIR Project in Boston. And I found myself just really fascinated by how much these folks were up against, and then how much impact lawyers had when they were able to make contact and stand up for, making sure these people had access to counsel, had access to their families. I saw that people's chances really changed. And so I was very lucky to be able to do detention work through an Equal Justice Works Fellowship. And as a result of that work, I kind of got thrown into both the world of bond, habeas corpus, and also learning, crim im and the categorical approach. And once I started, gaining some expertise in that, it kind of one thing led to another, and I've done that work my whole career.
It is pretty intoxicating once you start getting good at the categorical approach and understanding it. You're like, wait, what is this? This is wild. The PAIR Project is great. I also went to law school in Boston, and that's one of the first things that got me into immigration as well. Downtown, right near the stadium. Yes, where the Celtics play. It's like you go in there. To me, it was like old school lawyering. Like this building, like this is what you think of a lawyer from, like, the 50s, 60s, 70s going into this building and representing people.
Yes.
Same with Crowbar down in Harlingen. During law school, we went on a trip to that organization. And that's one of the things that got me into immigration. So maybe a bit of a similar path there. The importance of the nonprofits who are under attack right now and how they create the next generation of lawyers. Maybe that's one reason that the administration goes after the nonprofits.
I mean, I think the entire bar has a job to do in terms of trying to keep access to counsel and be one of the things that a lawyer does is kind of serve as a witness of what's going on in the courts. So most of my career has been in nonprofit work, in part just because some people can't afford a private lawyer, but there are many absolutely excellent private lawyers, including in the detention space, who I really enjoyed working with. And I really value the experience that I've had when I meet somebody who's done detention work. We have a really shared experience of driving hours to a jail, of, not being able to get in and see someone, of having to go down the street and make copies, of having our whole day lost to, various mishaps, but also just like how incredibly meaningful it is to be inside a detention facility and be the person that is advocating for someone who doesn't know how to get evidence or call their family members. And so, I tell law students that all the time. And frankly, it's bigger than immigration. If people get a chance to do criminal work, death penalty work, visitation work, I think we have a lot of people in different custodial settings in this country, and it's a part of our country that we should know about what's like for people who don't have their liberty. And so if people get a chance to represent folks in jail or detention, or even just to visit someone, that's an important professional and personal experience.
Well, whether it's state, federal, or immigration, it's more rare to see the defense bar or the removal defense bar or the criminal defense bar rise to a judgeship. And it's even rarer, I think, to do it at the appellate level. So what is the path to the Board of Immigration Appeals for a removal defense attorney, and how did you pull it off?
That's a great question, Kevin. I'm not sure that there is a path, but I'm very gratified that I was able to make it work, even if it lasted a little bit of a shorter time than I was planning. It is true that, both in the criminal and immigration system, you see more people coming out of government work and prosecutorial work on the bench, although that too goes in waves. And for me, I had clerked at the New York Immigration Court. I had practiced in front of really great immigration judges in Boston and New York throughout my career. And I had seen that being an immigration judge is an incredibly hard job. It's one that, when done really well, allows people to feel like they've been heard, even if they don't get the right outcome that they want. And that was something that really interested me after several years in practice, that I thought, I'm going to throw my name in the hat. And so I started out applying for immigration judge positions because the board positions don't come open that often. It's a much smaller group. And then it just so happened in 2020 or 2021, early 2021, that DOJ posted for an appellate immigration judge job. And I had been doing a lot of appellate work in my previous position at Brooklyn Defender Services, expanding our board and circuit court work. I had been on the AILA amicus committee and really enjoyed that. And I thought, well, maybe if this is the moment that they're willing to consider someone from a different background, I could explain that I have something interesting to bring. And so I really can't tell you why it worked out for me, except that you don't get the jobs you don't apply for. And I threw my name in and had a few interviews and was offered an appointment. And when I was offered that appointment, I thought to myself, if I don't take this opportunity, I'm pretty sure I'm going to regret it. When the board issues decisions, I'm going to think about whether I could have, given my perspective and given my comments. And so I took my family and I came down to Arlington.
It's a very good answer. You could have just said bribery. I've heard from multiple people that you have given a lot of money to individuals at the Department of Justice, Maine. I don't know how you got through the security gates, but that you did, and you used all that big nonprofit money to buy your way into Falls Church. Can you respond to that? That I've heard from many people are saying this.
I have always taken my DOJ ethics obligations very seriously, Kevin.
But you weren't in DOJ yet, is my point. That you were, okay, well, so you failed that question miserably. How many members at the Board of Immigration Appeals have this detention experience of having a whole day wasted to try to make copies or not to be able to go and see their client, and knowing the hardships of doing so? And not just board, and after you answer the board members, even the attorney advisors. I mean, I was an attorney advisor in San Diego. I certainly didn't have that experience. So how many of the people at the board have that similar experience? And how does that affect how cases are decided at the board?
Very few. It's hard to say how that affects any particular case, right? But I do think that personal and professional diversity allows us to make better decisions. It's nice to be in a room where someone raises something you hadn't thought of before. And so when I joined the board, I was the only member of the board at that time who had spent most of their career representing immigrants. And in the following 2 years, we added some more folks who had done removal defense and detention work, just one or two. And during those years, we had some really great conversations. The board has to work in 3 judge panels. It has to consider precedents en banc. And I was not afraid to bring up my professional experience. And sometimes I got outvoted fair and square. But I do think it is useful to know what it's like to build the record, or to deal with someone who has a lot of vulnerabilities and challenges in explaining their claim. And other people had a lot of professional experiences that I haven't had, right? People who are on the immigration bench are coming from USCIS, they're coming from JAG, they're coming from different backgrounds that I've worked with in the nonprofit field. So I found that all very interesting. And attorney advisors and judicial law clerks also, I would say, especially the younger folks, are often coming from law school clinic backgrounds where they have had some client experience. So we did have a pretty good mix.
It's a great answer. Also successfully avoided my attempt to have you label the entire Board of Immigration Appeals. So I guess the better question is, how do you think that your experience representing people in detention and being a woman of color, a Latino woman, how did that affect how you looked at an appeal, how you looked at a case and thought about the issues, if at all?
Yeah, no, I think it's a fair question. And I think in terms of the personal, what I think it has more to do with is that it was really meaningful for me to be there with other attorneys, with the younger judicial law clerks and attorney advisors who were looking for their future career path. And I just, it has to be said that in this field, especially in removal defense and in detention, the majority of the respondents are people of color from all over the world. But that's not really the case for the lawyers and judges who listen to their cases. And that's not to criticize any particular judge or decision. It's just an aspect of the judicial system that I think we should acknowledge. And it can make young attorneys feel like they don't have a place, or that certain career paths are closed off to them. And I know that because people have told me that my whole career. I've frequently been the most senior person in a space, in a law school, in a nonprofit, who's a lawyer of color. And I've had young folks say to me, I've never had a supervisor who was Latina. I've never had a professor who was Latina. And I was taken aback by that and, think, how can that be? And so I had that experience at DOJ as well, and tried to have an open door and be there for people and let the staff know that they also have a bright future in this field. So I think that's one aspect of it, right? it's hard to say that my personal and professional experience is directly related to any particular case that you look at, right? But I think in general, it's really useful to have the context of when you're reading a plain paper transcript to know something about what is happening in the courtroom or in detention at that time. And I would never go into things that I couldn't see in the record, but when you're talking to your colleagues about what might be going on here, what might be good questions for remand or for supplemental briefing, or what else needs to happen in this case to get the facts and law to make the right decision, I think it's nice to have people who have been on both sides of that, of the government and representing people, to sort of know the range of options and what could be going on with someone. I mean, that definitely came up, for example, in the mental competency cases, which is something I have a lot of experience with. What are the possible questions we can have the judge ask? What are the possible safeguards that we could be recommending? Some of that's in the case law, and some of that's going to have to be developed within the record. And so having some context for that kind of case gives you some more options.
Ethnic and cultural diversity on the bench is one of the so many realms of the cultural war we currently fight. I believe that ethnic and cultural diversity on the bench is a positive, but I'm curious as to why you think it's a positive from the point of view of the respondents. The mentorship that you just mentioned is well taken. To me, for example, understanding culture of the respondent before an immigration judge, that could go to credibility. Maybe the default is that the person is not telling the truth, when actually this is a tick from that culture, from that community, because there's a cultural divide. Are there any other things that come to your mind about why diversity on the bench is important to adjudicating cases?
Think some of it, I can't say what it's like to be a respondent in this situation, which could be very stressful. I have no idea, what might be going through someone's head when they get one judge versus the other. But I do think that having a judge corps that has a lot of personal and professional diversity is also good from a training perspective, because it is important to have cultural competency when you're dealing with cases from all over the world. And how would you know what that you're missing unless you have a wide range of people thinking about that? So, that comes up, as you said, in the area of credibility, where we know that people from around the world may speak to someone in power very differently. If we have certain ideas that a person who's telling the truth only does one thing, they look at you a certain way, their voice is a certain volume, they gesture or they don't, do they show emotion? It's important that we have a range of experiences of what that could be like and what the barriers are for people. This is a very small example that I'll give you, but as I think Latino people often have two last names.
Yes.
Right. And so their last name is actually both last names. It's not just one or the other. That's not everybody, but it's a lot of people. And so when you have a case name with someone with two last names, you use both of them. Now, if you do federal court work, you'll know that sometimes when you go to file a case in federal court or circuit court, sometimes they'll docket the case only with the second last name. And it's actually not correct. That's not how the person refers to themselves. They refer to themselves either with both surnames or just the first one. And I remember that I noticed that. And at one point I think I had to call the Second Circuit and ask them if they would change the docket, because that wasn't right. And it's such a tiny thing, but it makes you think, how did that docketing practice happen? It's because there just wasn't someone in the room when they made the system that said, hey, I don't know if you know this, but people actually use both last names. So it makes me think sometimes, what are the other small but meaningful things that we don't know that we could do better if we had more personal and professional diversity in the room?
You've struck a podcast nerve, because with every Hispanic case that I do on the show, I have to decide how am I going to refer to this individual. And the first last name is usually what the courts pick. So anyway, I've gone by what the courts pick, even when the courts are wrong, because that's how I'm safe in the four corners. And they usually pick the first last name. I have no problem with the two last names. It just makes for a longer case review. But I have to be saying both last names. I'm always up against the clock in a case summary. So the little things for the podcast as well. But I absolutely have noticed that. I think the circuits 90% of the time they do get it right with the Hispanic names, but it's been a while. And that's just the presidential cases where they probably put more time into getting it right. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. We have now reached the time in the interview where, as you promised me offline, you are going to spill all the tea about the Board of Immigration Appeals and say just everything that the private bar has been waiting to hear for 20 years. So with that, I'll just let you go. Judge Saenz, please spill the tea.
I don't recall that exact conversation.
Well, it happened.
But I am happy to answer a couple questions about how the board works. I actually find that there is a lot of information that this is going to sound so boring. There's a lot of information that's in the board's governing regulation.
Oh, my God.
That is actually true, but it's probably more interesting to hear someone explain it. So I'm happy to take a couple questions about it.
Kevin, I'm happy to discuss the 8 CFR if your listeners would like me to go section by section and subsection.
It's a very long regulation, so I can understand people don't make it all the way through 8 CFR 1003.1.
Oh, she even cited it. To be clear, that conversation did not happen off the record, blah, blah, blah. We didn't do it. I do have a list of questions, though, that I'd love to know the answer to just as a practitioner.
Sure.
We file these notices of appeal at the board. We don't really know what's going on, and we can call, but we deal with a very helpful, usually very helpful, but non-attorney clerk. We don't really get to know what's going on. I have actually been to the big building in Falls Church for my attorney advisor interview, but most people never have been. So I guess my first questions are, how are cases assigned to an individual appellate immigration judge, forget about the 3-judge panel and requesting that, but how did you end up with a case rather than some other appellate immigration judge? And then how are the attorney advisors used by the appellate IJs?
Sure. So the case gets sent to attorneys after it's already set. The briefing schedule is done. The briefs are in, and someone's checked the file to see that everything is ready for adjudication. And at that point, the case goes first not to a judge, but to an attorney advisor. So the board works on kind of a staff attorney model, very similar to what I did when I was a Second Circuit staff attorney as well, which is that the staff attorney first gets the case, they review the whole file, and they make a recommendation, and then they send it out to be assigned to an AIJ who they don't know who that's going to be yet, all set with a draft order to see if that works. And so the attorney advisors have a really important job of doing initial screenings and seeing how difficult the case looks, and proposing an initial resolution to the case, sometimes making notes on an alternate resolution, and writing a full draft order that sometimes gets signed the way it is, and sometimes gets completely revised or converted to something else. And so when I got a case, it would be after an attorney advisor had already reviewed the file and made a recommendation. And then I would get that file and decide if I'm going to go with that recommendation. Maybe I think it needs to be a 3-judge case, make my own edits, sign it, and get it to docket.
Many questions based on what you just said. So first off, all of the preliminary stuff before a decision is drafted, if a briefing extension is going to be granted, if the case is going to be kicked because a brief wasn't timely filed, all of that stuff is whether a 3-judge panel, well, not 3-judge, all of that stuff happens before any attorney sees the case. That's all happening at the administrative level before it's even given to an attorney advisor.
Right. There's a lot that goes through the clerk's office in terms of the briefing schedule and the timing. And sometimes you file motions and nothing happens to them. That's because they're still in the clerk's office. And then, things get kind of batched and put together and finally sent to a judge.
So putting aside motions to reopen, it's the clerk's office that's deciding lots of motions without any attorney advisor or BIA member getting involved?
Well, I think that's changed over time, just in terms of, flagging whether things appear to be timely, or the briefing extensions and things like that are usually first dealt with in the clerk's office.
Do you think attorney advisors draft their decisions differently, knowing who the board member they're dealing with is going to be?
I don't think I can say for sure what attorney advisors are up to, except to note that these are some really hardworking folks who have, who really need to get a lot of work done, which is probably true for other judicial law clerks as well. And so they are drafting decisions hoping that they won't have to revise it heavily.
That's right. And then, based on what you just said, they actually don't even know who the reviewing appellate immigration judge is going to be while they're drafting.
Right. So you asked how it gets to me or any other judge specifically. And the answer is that the legal assistants sign them randomly.
So the AAs, though, they're drafting it. They're not drafting it for any specific judge. So they're just drafting it based on what they think the law requires. Right.
So the attorney advisors are writing for a subset of the board. Maybe it's a group of 4 or 5 judges for administrative efficiency. The board works in panels. And this is why I referenced the regulation, because the regulation does talk about a merits panel and a screening panel. So half of the attorneys are working on a screening panel to try to catch all the simpler cases, or cases with obvious procedural defects, or they're just one issue, or maybe a shorter brief. And then the rest of the cases are getting pushed to a merits panel, which is more complex cases, more 3-judge cases. So at least the attorneys know that they're in one of those 2 universes, and which judges go with those 2 universes. But other than that, that's right. They don't know exactly who they're writing for. So they are trying to do their best, apply the law, what they think is likely to get issued.
And to be clear, I don't think there's anything nefarious or improper about what I was suggesting that an attorney advisor would be writing with the reviewing judge in mind. I mean, the judge is the judge. The attorney advisor is not the judge. When I was an attorney advisor and when I was a federal law clerk, I absolutely did that. You know your judge, you know what he or she thinks, and you draft accordingly. But that's not even always happening at the board.
Sure. No, I think that's also the case that, right, if you were a federal clerk and you knew your judge had a certain view of the law, then you would use that to inform your opinions.
Yeah. How are things determined to be made precedential or not?
So every case that's a precedent at the board that you see with the BIA tag, not the Attorney General tag, and I'll put aside these kind of more recent ones that have been designated as a precedent. That's a little bit unusual. I never saw that myself.
Woo.
But otherwise, all the precedents have been voted on by the full board. So there is a process where the 3-judge panel, somebody on that panel suggests that the case that they're working on should be a precedent. And then there's an en banc process where the entire board comes together and discusses the case and discusses whether it should be published and votes on it. And cases that get a majority vote can be published. And those that aren't have to either consider revision or go out unpublished. It's really a really interesting and useful process.
So the initial impetus comes from an appellate immigration judge who essentially calls for an en banc discussion.
Yes, exactly. So a judge can put up a case basically and say, hey, do you think that we should consider this at en banc? There's a vote for that. And then there's a full discussion and a vote on whether it should in fact be published.
And so hypothetically, if you were to fire all the board members who were appointed by Merrick Garland and other individuals who might not align with the Trump administration's view of immigrants, then it becomes easier to make certain decisions precedential because it'll be easier to get a majority during this en banc process, hypothetically?
No comment, Kevin.
No, well, that's just math. And I understand we're lawyers and we're not supposed to be good at math, but you can leave your no comment where you like. I'm curious about the Attorney General, your interaction with Merrick Garland, how the appointment process works, and Merrick Garland in particular's involvement with the Board of Immigration Appeals. I mean, administratively, the BIA speaks for the Attorney General. It's not an independent entity. It's kind of like the voice of Sauron. If you've seen the extended version, Lord of the Rings, I don't know.
Yes.
You have. So that's an apt analogy. What was your involvement and interaction with the Attorney General, and what is the idea of the Attorney General's involvement at the board?
So it's much less than I think maybe you would find interesting. I did not get a chance to meet the Attorney General at any point. I think the main theory is that the Attorney General has delegated a lot of authority to the board unless he or she decides to take back an issue and start issuing those AG decisions that you see, which I think is really interesting because it kind of seems like once an issue has been taken up by the AG, it then can only be answered by the next AG. So that issue almost sort of like leaves the board's purview. Yeah. But I personally did not get a lot of interaction with Main Justice. I think I met Lisa Monaco briefly, who was the Deputy Attorney General. And I got appointed during the height of COVID times. And so everything was on Teams or Zoom or WebEx. And I didn't even get a in-person swearing in ceremony, investiture. Which is really sad because previous and later classes got sworn in at Main Justice with the robe and the whole thing. So I didn't even get that, Kevin. But we did have some, passing visit from the deputy AG just to answer questions and tell us that we were doing a good job. Other than that, there was definitely not a sense of this is what the Attorney General wants the board to do. I do think that generally the board is exercising its own judgment about what the immigration laws should be. And so if there was ever an AG decision or a regulation, we didn't know about that. We didn't have inside information. We would learn about that AG decision when it was issued, just like the public.
It tracks completely that the Democrat AGs are leaving the BIA to its own devices and not really making known what they want their BIA to do. But do you really believe that is currently the case with this BIA and that the Republican AGs are taking as much of a hands-off approach.
I can't say what's happening inside. I'm just not there.
Do you have any idea why it is that the Trump AGs during the first term issued almost 20 precedential decisions and Merrick Garland issued 6, one and only one of which was actually of substance and not simply reversing a prior AG decision?
I certainly can't tell you why, but I can say that there were issues that I thought were going to get AG decisions for sure that left some cases in limbo. So when I got to the court, when I got to the board, we were still putting cases on a negotiate hold.
That's right.
Where there was a persecutor bar issue and you couldn't resolve the case on any other ground. And when I left, they were still on negotiate hold. And that was odd to me. So I can't say, how often people should use that AG power, but I certainly thought that we would see some decisions that we didn't see.
Can I ask actually the most important question? Is it Negussi or Negus? Because I thought it was Negussi for a long time, but there is a congressman who's got the same spelling who goes by Negus, I believe. Do you know?
I have no idea. That's a good question. And I do think that where we can figure out how to say people's names correctly, that we should.
You wouldn't believe how much time I spend actually doing YouTube, trying to find the oral argument to at least see how the attorney does it for the podcast.
Well, I greatly appreciate that, Kevin, because I have a hard last name to say, Saenz. People do not know how to say it. It is actually a last name that's in a famous Supreme Court case, Saenz v. Roe. It's a case about the right to travel. And so sometimes people have heard of it, but usually they're just taking a stab. So I do try to say people's names correctly if I can figure it out.
It's all right. I get called Greg with 1 G all the time. And now my wife is getting called Greg with 1 G, which makes even less sense. So I sympathize on the last name, but it is easy to say. Final question about your time at the board, and maybe we can follow up if people want to email me. I'll just forward them blindly to you. How do the board members interact with one another? What's it like? It's, you guys are colleagues, you guys are equals. Yes. How does that look day to day?
Yeah, there's a big range in terms of what people prefer, in terms of what communication they like on cases. So a lot of it is written, which I think makes sense for an appellate board, but there are opportunities to make notes on cases and to send emails and to use Teams. Sometimes there's, video calls. And during my time at the board, it was very hybrid. So you had some people in person and some people elsewhere in other cities and other courts. So even en banc was done hybrid, where you had people there in person and some people on the screen. And people shared their comments, in all those different ways. So for me, I am used to having a big team and, sharing stories and talking in person. So I had my door physically open at the board, and I liked when people came in my office to say, what do you think about this case? And other people prefer to, put their head down and send you their thoughts in writing. So there wasn't anything that was absolutely required. So there was a big range.
I take it back. I've got more board questions. What was your favorite part about working at the board?
This is going to sound really nerdy, but it was really an opportunity to think about the law almost all day. And I think probably other people can relate to this if you end up in a management position or you're running your own practice. And I was running a team of 40 staff and I loved it. But a lot of my day by the end of that time was not very legal. It was a lot of, administrative stuff and personnel and budget and advocacy. And I enjoyed that. But I also used to be the person who read every Second Circuit case when it came out, and I didn't have time to do that. And so when I got to the board, I had the opportunity to read every case email, which I would do. And then I would listen to your podcast to reinforce it and think about the cases that I already knew and what were these new cases and what did that affect? What kind of cases were coming in that should be a precedent or that we should do a training about. And it was a very, thoughtful and meaningful way to spend the time. And so I really felt like I was in the library, up with a bunch of books on my desk, trying to actually get to the right answer in every case. So I really, really enjoyed the job.
That's great to hear. But you bring up another good point. So I have a competitor within the government for case sum. What is he or she's name, and how do I contact he or she? My competition. Who's making the summaries? That is my internal government competition. I assume she doesn't have a podcast, but how do I?
Well, it's good to hear. It's good to learn things in different modalities. So the ER library staff, they've got someone who sends
library staff.
They've got. I don't think there's a physical library, but we did used to get a case law email every week. And then at the board, because it was so important that we knew cases even faster than that, we would often get a same day email if there was a particularly big precedent or some, injunction or new regulation or something that we would get a same day email. And so I like to be able to read it and listen to it. And sometimes it would actually get in there.
Let the record reflect Judge Saenz did not name names.
I don't know who writes those emails.
You received it from someone, but it's okay.
It's from literally your library or something.
Oh my gosh. Unreal. You're
going to have to FOIA it. I'm sorry.
That's right. Someone will do it. Now, this really is my last question, but for the board, but it also for you. How is Loper Bright being talked about at the board, and how do you think about it? If there is no deference to the BIA's interpretation of the INA, that's a big chunk of what the BIA used to do, and its whole point. How is Loper Bright being discussed there, and how do you think that affects how it operates going forward?
That's an interesting question, because I think it might be a big chunk of what oil used to do, right? But it wasn't necessarily invoked by the board in the first instance, maybe in the Brand X context, right?
Yeah.
But this is something that I thought was coming, that I think a lot of people thought was coming in the last couple of years. And as a result, I think there was an awareness among many folks at DOJ that the board really had to show its work and do good statutory interpretation. And that was going to be our best bet, whether there was formal deference or not, to have the circuit courts agree. So I actually think you see that. I mean, there were a range of opinions at the board. I didn't agree with everyone all the time, but there were a lot of folks working really hard in good faith to explain their reasoning, whether we all agreed or not. So I do think you see some of these cases from the board in the last 3-4 years that had more statutory interpretation in them than maybe you would have seen 20 years ago, because there's this acknowledgement that, okay, that's what the circuit courts are looking for. They don't want us just to say, oh, we know better. We're the agency. Trust us on this. We're going to have to go through the steps, cite some Supreme Court case law, analogize to something else. And so I think that's the major response to it, is just the knowledge that, the only way that the board's decisions get adopted is if they have a lot of good reasoning.
I'd be very grateful for some, and I know my listeners would too, for some appellate brief writing tips, both from your time as an appellate advocate and as an appellate judge. I mean, what are the good things you saw, and what are the good things you did and do?
Sure. And that's actually one of the things I do at co-counsel now, is do training and support on appellate issues, because I do think that legal writing is really important. And I think, what people need to realize, both in terms of their immigration judge briefs and their briefs to the board, is that the adjudicators are going very fast. They have too many cases to give extremely slow readings and thinking about the law in every single case. And so it's really important for people to get to the point of what their case is about and what their winning issues are, what the dispositive issues are. And especially at the board, I think the best briefing is that which is really digging into the immigration judge decision and the record and saying what went wrong and why does the board need to do something about it. Sometimes people write a board brief that is very similar to their pre-hearing brief, which doesn't tell you what went wrong at the hearing, or that has a lot of legal boilerplate kind of telling you what asylum is, which is something the board does know in terms of what the case law says. And so the best briefing, I think, is that which really gets to what are the 2 or 3 core issues in this case, and why is it that you have to reach them? You can't, just dismiss this on another issue. This is what the case turns on. It changes the burden. It changes the credibility analysis, and really applies board and relevant circuit law. Sounds like a low bar, but sometimes that's not what people go for.
Do you agree that, and I don't mean this in a negative way, but do you agree that appellate adjudicators are looking for the path of least resistance, and that it's important to make a remand the path of least resistance?
I do. And I know what you mean. I don't think it's a negative thing. I think sometimes you can feel as an advocate like something went terribly wrong in a case, and that's true. And forget that the immigration judge denied your case on 3 grounds. And so the board might be able to affirm on a different ground that's not the one that you're very upset about. And so, if there are multiple grounds for denial, you have to address them all. And so, it's very important for people to explain why the board has to remand or has to reverse, and why the circuit court is not going to like it if they don't do something else, as opposed to, the best example of this is a due process argument, right? Which is, it's one thing to say I didn't get to present evidence. There's a due process violation in my case. But you also have to address prejudice. You have to address, why does it matter? Is it possible that evidence didn't make a big difference because there were all these other reasons for the denial? So if people can hit that head on, it's much harder for the board to ignore.
I think there would be a great service to the private bar that you can and should sell by creating some sort of small book, of course, with headings and that gets straight to the point, about BIA-specific best brief writing tactics. And I truly mean that. So if you've got the time and the desire, I would certainly appreciate it. But before we go, I'd love to hear really what co-counsel is and what you're doing at co-counsel, besides advising them on best brief writing strategies.
Absolutely. So co-counsel is a small nonprofit started by a couple of my friends and superstar lawyers to help firms and organizations increase their capacity. So it works like a nonprofit or consulting firm that can come in and literally train, mentor, co-counsel, do all-day clinics, and help either organizations that don't have a lot of their own legal staff or organizations and firms that just need a little support to expand their own skills and capacity. And so they have lots of their own projects and wonderful partners going. But one thing that I am doing is doing training and mentoring and strategy for folks who are interested in improving their appellate skills or having me help them on one of their appeals. And so people are welcome to reach out and work with me on that.
I'd be honored to share your links in the show notes of this episode, and we'll do so. You've been very generous with your time, Judge Saenz, and I appreciate it, and have directly answered my questions, which I also very much appreciate. I guess my final question is, where do we go from here? What does the future look like for the respondents bar? We are 5 months in to what is very clearly a war on our clients and potentially a war on our profession. This feels different than Trump 1. You and I were both in the non-citizens bar during Trump 1. What do you think the next 3.5 years look like? And what should the bar be doing during this time? What does the future look like? It's a completely unfair question, but I'd like to hear what you have to say.
It's a good question, Kevin, because we're all wrestling with it. And it is a really hard time. So the first answer that I have to your question of what we should all do is that we should all take care of ourselves and each other so that we continue to stand up for the rule of law and for the court system to be able to provide justice and for our neighbors and our communities. So it's really hard to know specifically where immigration law is going, and I'm not gonna guess. It's been a difficult time. I'm, hearing about these courthouse arrests every day, hearing about people scared to go to work and school. It's hard for me to think that anyone is enjoying hearing that news. And it's really emotionally overwhelming sometimes. And that's one thing that, even when I was a judge, sometimes we sort of act like lawyers and judges are neutral in the sense that they don't have human emotions, as opposed to that they're able to come to the case neutrally, right? Like that they can be fair to both sides. But even a judge has emotions. And I think we're seeing some of the immigration judges now have human reactions to seeing people leave their courtrooms and be arrested. And so part of what we do, I think, is to take it one day at a time and not think that any of us can possibly represent every single person who needs help, because that is overwhelming, but to keep doing it, to stay in the work, to take the cases that you can take and be healthy and go to sleep and eat food and check on your friends. I mean, that sounds like a silly thing, but I think that we have to keep standing up for each other and for the rule of law as long as we can. And I truly believe that the bar has an important role to play and can bring this information to the public and to decision makers about what it takes to make sure that our court system works and is a tool of justice as opposed to a tool of fear.
It's a marathon, not a sprint, so stay hydrated.
Absolutely.
Before we say goodbye, I'd like to give you the floor to talk about anything you want. If there's something that you wanted to talk about that I missed that you think would be of benefit. I know it's late on the East Coast.
No, I think we did a really good job covering this, Kevin. I'm really happy to be back in this community. It is a really special community of people who are trying to be there for our neighbors and each other. And I am just trying to do my part.
It's been an honor having you on the podcast, Judge. Thank you for spending your evening with me. I wish you nothing but the best going forward. I hope to see you back in government someday. And if nothing else, I hope to see you at a conference soon.
You will. That one I can guarantee you.
Thank you, Judge Saenz. Have a wonderful night.
Thank you.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.